Okay, let's start. Hi, everybody. Welcome to another one of IFF's members briefing calls. We do these calls often enough. We do them for our members. We also live stream them on YouTube and Twitter and various other places. So anybody who's tuning in, hello. Thank you very much for joining. I know it's a Tuesday and it's a good time to talk about this. We'll be talking about the proposed amendments to the IT rules 2021. These amendments talk a lot about gaming platforms and online games. I am the Senior Litigation Counsel at IFF here. My name is Tanmay. I'm joined by my colleagues Ramya and Gayatri, who are also both lawyers and Associate Litigation Counsel at IFF. Ramya is going to start us off. So why don't you go ahead, Ramya?
Thanks, Tanmay. So I hope everyone's having a good evening, and thank you so much for joining us once again. My name is Ramya. I am the Associate Litigation Counsel here at IFF, and I'm also the Case Intake Manager here at DPTC. So today we'll be talking about the IT Rules 2021 and the draft proposed amendments. But before we get into the amendments that came out on 2nd of January and we sit and discuss them, it makes sense to just quickly go through what is the history and what have we been through till now since 2021 with the IT rules. So next slide, please. Great. So the IT rules 2021 came out on 25th February 2021, and they superseded already existing IT rules that came out in 2011. And what was really game changing and what was really transformative about these rules is that they attempted and are expanding the scope of the IT Act through rules. So this was a theme that you will see throughout in our conversation today, that though the scope of the IT Act may be restricted to say X, the rules and amendments that the government and MIT keep trying to propose continue to expand its scope in numerous and unconstitutional ways. So that is basically the underlying thread current that runs through all these amendments that we will be discussing. So to start us off, what are the issues with the IT rules 2021 when they came out firstly in February? Next slide, please. Thank you. So they chose the IT rules significantly increased control on three groups, right? One is intermediaries, including social media intermediaries, and a new classification called significant social media intermediaries. Second is OTT platforms like Netflix, Hotstar, Hulu, etc. And third is digital news outlets. So we have in the past in detail delved into what these are, but to quickly just refresh your memory, one example is that OTT platforms and digital news outlets are not covered in the IT Act itself. So it is the first time that these rules are proposing regulation and trying to govern and dictate how OTT platforms and digital news outlets should operate, even though the scope of the IT Act does not cover this, right? So this is one of the biggest flags of concern where we're seeing an expansionist approach to trying to get as many things that you engage on the internet, right? Outside of work, most of your time is spent on Netflix or Hotstar, or you're reading news online, or if you're a lawyer, you're on bar and bench. These are kind of things that are trying to be taken over and controlled within the scope of the IT Act without actually any legislation being passed. Secondly, another cause of concern is the oversight mechanism these rules propose. So for example, Rule 9.3 and Rule 13, they propose a oversight mechanism where the government can sit and appeal content takedown orders and decisions intermediaries take on whether X tweet should remain online or not. So this is also another cause for concern where it's not only are we worried about big tech and we're worried about the decisions, like, for example, Twitter would take on whether a tweet violates their guidelines or not. But now the government sits in appeal over and above Twitter to determine whether or not such a tweet should remain online or it can be taken down, etc. So this is a huge threat to freedom of speech and expression and something that we're really concerned of. But this was a quick refresher as to what the IT rules were, right? But what I'd mainly like to talk to you about today is the litigation that resulted in all of this. So if I can get the next slide. Yes, the strategic litigation. So there were three cases that I'll be discussing that came out of this. But the first one, which is LiveLaw versus Union of India, this was a case in which we were the lawyers for LiveLaw, and we represented LiveLaw before the Kerala High Court. And here, the background of the arguments was that LiveLaw basically argued that these rules are unconstitutional. The fact that they are governing news media as if they are an intermediary, and they're trying to restrict the ability of a news media operation to basically function and do what they're capable of doing, or publishing news, by requiring them to sit in judgment in overview of their own content. For example, if tomorrow LiveLaw publishes a report on a case that took place in a place X, and I somehow get offended to it, and I raise a grievance against LiveLaw for publishing this factual news piece about this case X, LiveLaw will now have to listen to my grievance, sit in appeal, and sit and weigh down whether or not this piece of information should remain on their website, right? This creates like a lot of self-censoring, where LiveLaw is now put in a position that it has to sit and examine whether or not each piece of news information can be put out. It'll cause a lot of like increase of load for LiveLaw to determine what news pieces are acceptable and not acceptable. And in a sense, it takes away from your ability to report freely and be freely, right? But finally, the another argument is that, coming back to what I spoke earlier, the IT Act does not govern digital news media. Nowhere does that in the IT Act does the word digital news media come up. So these rules, through these rules, they're trying to get publishers like LiveLaw into its ambit, right? So these arguments are still ongoing and pending before the Kerala High Court. But while this was pending, as you can see on the slide, we were successful in obtaining protections for LiveLaw. So the Kerala High Court was pleased to direct the government to not take any coercive action against LiveLaw for not complying with part 3 of the IT rules till the pendency of the case. So again, just to repeat, part 3 of the IT rules requires 3 levels of self-regulation. The first level is self-regulation by the publisher themselves. The second level is self-regulation by the self-regulating bodies of the publisher. And level 3 is an oversight mechanism by the central government, where the central government sits in final appeal of all the content takedown or any other grievances you may have against LiveLaw. So that was a great big win for IFF. But there are 2 other orders that I'd like to talk about. Next slide, please. Yes, so we had another case, TM Krishna versus Union of India. This was before the Madras High Court. We are the lawyers for TM Krishna before the Madras High Court as well. And in this case, the Madras High Court was pleased to order that any action taken by the respondents being the government here, against the petitioner, that is TM Krishna, under Rule 3 and Rule 7 would be subject to the final outcome of the litigation. So for context, Rule 3 of the IT rules gives a bunch of conditions and prerequisites that a social media intermediary must fulfill, or an intermediary also must fulfill. And Rule 7 threatens that if you do not fulfill the conditions of Rule 3 and all the other rules in the IT rules, then they would be subject to penal prosecution. So it is a requirement to do certain things and a threat to get prosecuted if you do not do certain things. So this is an order we got in the Madras High Court, and so currently the government cannot take any action against TM Krishna for not complying with the rules required under Rule 3 till the litigation is over. Finally, which is the Bombay High Court order. It's Agich promotion of Ninitara Media versus Union of India. This is the only case in India where there is a stay in operation. So the Bombay High Court stayed the operation of Rule 9.1 and 9.3 of the IT rules till all further disposal of the litigation. So by stay in effect, it would mean Rule 9.1 and 9.3 of the operation of the IT rules will not be in operation. So 9.1 is the section that requires publishers to adhere to a code of ethics. And that code of ethics, if I may read, has requirements such as a publisher shall take into consideration India's multiracial and multi-religious context and exercise due caution and discretion while featuring the activities, beliefs, practices, or views of any racial or religious group. So in this code of ethics, so a publisher is required to keep this in mind, right? But given how broad it is, given how vague it is, it can be used and interpreted in any way to restrict a person's freedom of speech and expression, or lead to self-censorship, where someone will now doubt themselves as to whether I can create a certain type of art. Will it offend the multiracial and multi-religious context of India, right? So this is a slippery slope where, given the vagueness of the language of the appendix, it can be interpreted in many restrictive ways. So the operation of this rule, so the requirement to comply with these code of ethics, has been stayed. And secondly, section 9.3. Section 9.3 imposes the 3-tier of self-regulation. So level 1 is self-regulation by the publishers, level 2 is self-regulation by the self-regulating bodies of the publishers, and level 3 is the oversight mechanism by the central government. So here a lot of the setup in which you self-regulate yourself, then you appoint a body to self-regulate you. Then if you want to appeal that, then the government will determine which content is acceptable, which content is not acceptable on Hotstar, on Netflix, online. The operation of this has been stayed, right? And this matter is also pending. So what does it mean now? Where are we now, right? If I can get the next slide. Yes, so the story moves to the Supreme Court. So that is currently where we are at on our litigation front in terms of the IT rules. So there are 17 different petitions pending before multiple high courts all across India challenging these IT rules. So the government had made an attempt to have all the 17 petitions which are pending before the different high courts, to have them all transferred together in a batch to the Supreme Court so that the Supreme Court can hear it together once and for all. So this matter, this batch is pending before the Supreme Court. The Supreme Court needs to take a call as to whether or not they want to hear all these 17 matters, or if they want the high courts themselves to address whichever matter is before them. This is what is pending. And in the one of our latest hearings, the Supreme Court put a stay on all the High Court pendings. So, I mean, all the High Court proceedings. So, what I was just saying, like every case, the Kerala High Court judgment, Kerala High Court order, and the Bombay High Court order, and the Madras High Court order, all of these 3 cases are still pending, and along with the rest of the cases, because the Supreme Court has put a stay. So until the Supreme Court determines whether or not they wish to hear these matters, none of those matters will proceed. So that is where we are at the Supreme Court, but not to worry, because the orders that we have gotten in all 3 high courts, they are still in force. So the stay on 9.1 and 9.3 is still in place. The protections we have gotten for TM Krishna and LiveLaw are also still in effect, which is a thing to be really excited and proud about. Finally, next slide. Yes, so finally, that just concluded where we are at litigation with the IT rules 2021, which came out in February. However, in October, there has been a new amendment that has come to the IT rules, the IT Amendment Rules 2022. This introduced something called as a grievance appellate committee. So similarly to how Rule 9(3), which or Part 3 of the IT rules, which governs OTT platforms and digital news publishers, how they have like this three-tiered oversight mechanism with level 1, level 2, and level 3, which is described in Rule 9. The GAC proposes to do the exact same thing for Part 2, which governs intermediaries and intermediaries and significant social intermediaries. So it's basically the government is trying to replicate the same system that exists in Part 3 in Part 2 as well for intermediaries. They have Part 2 as of now had some provisions which allowed intermediaries to regulate their own content, to have their own grievance officer, and appoint their own procedures. So the government basically realized that this procedure is not being enacted by social intermediaries. A lot of people are allegedly complaining that their grievances with social media intermediaries remain pending and that the grievance officers are not addressing their concerns. And so the government chose then to like step in and take charge of the scenario by now introducing an appellate committee, again, without any legislative backing whatsoever. There is nothing in the IT Act that allows or mandates the ministry to enact such rules or put into place such rules through executive action. So yeah, now the grievance appellate committee is a committee set up by the government, and it is all appointed like government officials, and they sit in appeal over decisions social media intermediaries make. So this is also something cause of concern, but also follows the same thread that I was mentioning, where each rule tries to expand the scope of the IT Act. So this is where we are till October 2022. Now my colleague Gayatri will bring us to where we are at today.
Thanks, Ramya. So, hello everyone, this is Gayatri. I am a litigation counsel at to the state draft amendment. I have expertise. So, I go first. Of the do.
Gayatri, I think your audio is breaking up a little bit. Could you just sort of try to fix that? But in the meantime, just thanks, Ramya, for the recapitulation of what is going on with the IT rules in courts and then subsequently. I think the overarching theme is that the Madras High Court and also the Bombay High Court have outlined several problems constitutionally speaking with the IT rules and have found that there may be issues relating to the independence of the media and also of threatening free speech on social media, as a result of which several protective orders have been given out by both courts, which have not been stayed, which are still in operation. Now, what I find personally fairly interesting about all of this is that the government has, instead of trying to fix these issues, take note of what the courts have held. Instead of fixing these issues, it is going ahead and continuing these problems in other manners towards other entities to which these rules apply. One example of that was the GAC rules, which draft amendments had been put out last year, to which we had also submitted comments and we brought up these points, which were not heeded to, and the amendments sort of went through more or less as they were. And now they're trying to do something very similar with gaming intermediaries, which hopefully, Gayatri, your audio is working again. Can you just say hi, hello, so that we know?
Hey everyone, can you hear me now?
Okay, fantastic. Yes, we can hear you. So I'm going to give the mic over back to you, Gayatri. But before I do that, I just want to remind everybody that this is being streamed on YouTube and Twitter and other social media platforms for everybody. But after this, we will move to a members only exclusive question and answer session. If you think any of this that we're talking about is either interesting or useful or helpful to you, please consider becoming a member or a donor of IFF. That's kind of support really keeps us going, and it's what makes these calls possible. Thanks again. Gayatri, go ahead.
So just to sum up what Ramya and Tanmay have said, instead of curing the deficiencies of the IT rules as they were recognized by various state high courts, the union government is in fact furthering the illegalities and inadequacies of the IT rules. Next slide, please. So the IT Draft Amendment Rules 2023 were proposed by the Union government on 2nd January 2023. And the purpose of this is to expand the scope of the IT rules to include online gaming within Part 2 of the rules. The draft amendments were published just a week after MIT was appointed as the nodal ministry for administering online gaming. Prior to this, online gaming was not covered by the IT rules. The union government notified this change through amending the allocation of business rules, which means that MIT is now the designated ministry to administer these rules. What it does not mean is that the amendment of the allocation of business rules does not grant MIT the power to exercise this. In order to do so, there must be a clear parliamentary enactment. The union government cannot resort to delegated legislation like the IT rules to expand the mandate of the IT Act by including online gaming. Next slide, please. So the draft amendments were introduced without any discussion or white paper. A public notice that accompanied the amendments said that there was a need for the draft amendments to safeguard users of such online games against potential harm. But since there wasn't a white paper or any prior discussion, we don't really know what the union government means by assessing potential harms to users. So within Rule 2, there's a lot of definitional ambiguity. So the intermediary definition has been expanded under Part 2 of the IT rules to include 1, social media intermediaries, number 2, significant social media intermediaries, and number 3 now, online gaming intermediaries. There's no logical or reasonable justification that we know that the government has created another category. And this definition is also really broad. We're quite unsure if the definition includes host games like the Google Play Store or the Apple App Store, or whether it shall cover games which are single player offline and also have multiplayer online modes like EA Sports. Again, there's some ambiguity whether non-gambling online games will also be regulated by the rules. Again, since there's so much vagueness, a consequence is that since there's so much vagueness and the definition of online gaming intermediaries is not really determined, this may actually end up stifling growth and innovation in this sector, which also contradicts the mighty public notice, which said that the aim of these rules was to enable the growth of the online gaming industry in a responsible manner. Next slide, please. Uh, so again, the rules introduce a KYC procedure which has to be followed by online gaming intermediaries for registering accounts of users. This is also the same procedure which is mandated by the RBI to verify and identify customers at the start of an account-based relationship. So the consequence of this is that now the union government is vested with really broad powers to classify an intermediary as an online intermediary and exercise regulatory power for KYC in the absence of a clear legislative basis. Uh, Another amendment is that Rule 4B3 of the 2023 draft rules grants MITI the power to assess and register a self-regulatory body. Its proviso allows the union government to consult any appropriate government or any of its agencies for registering a self-regulatory body. All online gaming intermediaries are required to be registered with the self-regulatory body, and all online gaming intermediaries must have a demonstrable mark of registration. Under, under Rule 4B6, every self-regulatory body shall evolve a framework that online games will have to conform with. Such a framework could be continuously updated and evolved, and it may include things like testing and verification protocols. Given that wide powers have been given to the self-regulatory body, it's important that its independence is not only established but actively protected. However, MITI can, by an order, suspend or revoke the registration of a self-regulatory body. The wording of Rule 4B10 makes the exercise of this power even more arbitrary by including phrases such as it may deem necessary, and if it is satisfied that it is necessary to do so, alongside the ability to issue directions or interim directions. The broad powers which have been given to MITI further bring in a high level of government discretion in determining uh, which self-regulatory body will exercise these powers, and more importantly, how it will exercise these powers. Next slide, please. So Rule 6A gives MITI the power to declare any game which is accessible to users without a deposit as an online game if the game creates a risk of harm to sovereignty, integrity of India, security of state, friendly relations with foreign states, or public order on account of causing addiction or other harm to children, and it can do so by publishing a notification in the official gazette and recording its reasons in writing. The consequence of, again, this provision is that harm among children is not defined. In the absence of a white paper, we're unsure what MITI means by harm among children. Uh, Further, in the absence of a white paper, it is even more essential for it's more essential that we must have clarity what exactly the union government means by these terms so as to avoid inconsistent application or prevent misuse of the rules. Uh, so if all online intermediaries do not comply with the proposed rules, the penalty for non-observance of these rules remains the same as the penalties for other categories of intermediaries, which means that if online gaming intermediaries do not comply with the rules, they shall lose their safe harbor protections, just like other intermediaries. This puts a very high burden of compliance, especially when there's shorter timelines and younger and smaller intermediaries are would be much more adversely impacted by this. So now over to Tanmay, please.
Thanks very much, Gayatri. That was about the IT rules amendments, which focus on gaming intermediaries and online games. We will now move on towards the members only question and answer session, where you can post your questions to Ramya and Gayatri and also to myself. And we'll be unmuting people, etc. And you can also put that in the chat box. This is open only to members, so we will be switching off the live streaming that is happening currently on Twitter and YouTube, etc. If you are